All right, well, I think we might as well get started here as people filter in. I mean, the initial pieces here are mostly just an introduction. So Keith, you could take us to the next slide. All right, these are the panelists. I'll let everyone introduce themselves. Jacques, you want to go first?
Yes, thank you. Good morning or good afternoon, everybody. My name is Jacques Santucci. I'm the president of Opus Consulting. Opus Consulting is a business performance consulting firm, and we've been involved in the cannabis industry since 2010. Our team has been working on licensing opportunities, a lot of business planning and financial modeling. We also help our clients boots on the ground, starting operations, designing facility from a business standpoint, and then turnarounds and receivership of cannabis companies and other companies. So our team has been involved in a lot of different states in the past 13 years or so. And thank you, Charlie and FL, for having me on this webinar.
Thanks for joining us. FL, you want to introduce yourself?
Sure. My name's FL Gorman. I'm a partner at Vicente Cedarburg, recognized by Rolling Stone magazine as the first full-service marijuana law firm in the country. We're a boutique cannabis law firm. My background is in real estate, commercial real estate, and what I like to say, the full life cycle of real estate, from the front end of approvals and lobbying for government money to the dark side, bankruptcy and foreclosures and workouts. Earlier in my career, I was actually chair of the American Bar Association's Young Lawyers Division Bankruptcy Law Committee. At one point, I held the record for the most preference actions filed in a Chapter 11 case in the Western District of New York. And I've appeared in probably a dozen bankruptcy courts around the country, mostly representing shopping center owners and dealing with lease rejection, lease assumptions, and looking forward to participating in the panel with Jacques and Charlie.
Okay, great. Thanks, FL. So just my name's Charlie Vicente. I'm a partner here at Vicente, and I'm also chair of the corporate group. I'm based in Massachusetts, but I used to live in Colorado, and I do a lot of work in New York too. So those are sort of the three markets I focus on. That's my story. So yeah, if we could, I'll let Jacques, you covered
That's
it.
the speech. We covered this, but remember, everybody, this is the most important slide.
Yeah. That's the only one we're going to send around.
Yeah. Okay, good.
Yeah, this is us. So, just to correct FL's quote, Rolling Stone called us the first powerhouse marijuana law firm. But we're not just a marijuana law firm. We also do hemp and psychedelics and functional adaptogenic mushrooms. So we're branching out. Bunch of offices across the country. Pretty much anything related to cannabis, we can help with. Next slide. And, I'm contractually obligated to hawk my book at every opportunity. So I wrote a book on cannabis law called The Cannabis Business. I think we still got 5-star review or close to it on Amazon. All the profits go to Last Prisoner Project. Here's a discount code if you want to buy it directly from Rutledge instead of buying it on Amazon. Save you a little money. And next slide. Okay, so let's get into the meat of the agenda here. So we're going to start off with the state of the industry, which I'll cover. FL will talk about bankruptcy and cannabis. Jacques will cover why receiverships, selection of receiver and other considerations, and then FL and I will cover state-by-state cannabis licensing issues. But we're going to interrupt each other as we go along and talk about what we find interesting. And of course, if you have any questions, please type them in, because we're going to save the last 15 minutes here to talk about any questions that the group might have, which hopefully we can answer them, though. Just to preface, I'm sure we'll get these questions, but a lot of things are ultimately up to the judge in a receivership, so it's tough to provide definitive answers like you may be able to do in a bankruptcy, federal bankruptcy discussion. And of course, if you are, focused on receivership law, feel free to, reach out to us after the presentation. We'd love to discuss, because we are, I'm an M&A attorney by training. FL is a real estate attorney. Obviously, we both have done a ton of cannabis regulatory work, but we are not receivership lawyers. Not trying to claim that we are receivership experts. To me, this presentation is about understanding at a high level how you can use receivership strategically. If you
Yes.
actually are going to file for a receivership or try and push someone into receivership, you will want receivership, specialized receivership counsel, which of course we can provide referrals for. So with that said, let's go into the state of the industry. Okay, so obviously the state of the industry is why we're having this discussion today. We'll I guess just talk about the industry as a whole, right? So there's the good news, which is, we're talking about a $33 billion industry, according to MJ Biz Daily. Now, you could get different figures, right? I see different numbers. You debate what the size of the industry is. It's different ways you can calculate it. But the point is, it's growing, right? And this next list, these states are new states that have come online recently with adult use cannabis. Of course, there have also been some new medical states as well, like Mississippi. But it shows you, despite the challenges, this is going to be sort of a negative presentation talking about the challenges, there's still a tremendous amount of growth in this industry. Personally, obviously I'm biased, but the tri-state area coming online to me seems like a game changer. I mean, this has always been seen as a West Coast industry. But, to have cannabis legal effectively contiguously, right, from Maine down to New Jersey, you can drive from northern Maine down to southern New Jersey, and until you hit Pennsylvania, you can buy adult use cannabis the entire way. So that to me is a massive change. I mean, obviously,
you have a 20-mile problem with New Hampshire, I think, but otherwise you're good.
Oh yeah, of course I live between New Hampshire
Yes.
and Massachusetts, but it's a very short drive.
Yes, very sure. You have a good point. A lot of people are asking me why, financial issues and turnarounds and receivership in cannabis, because the industry is still growing, but I think it's coming with the few items that we have here on the screen. There are some fundamental issues that are coming to the surface that are creating some dysfunctionality all around the industry.
Yeah, and well, what got us here, right? Part of it is high taxes. So, in a number of states, particularly California, which I think was sort of a bellwether for the rest of the industry, the high state taxes combined with the federal taxes that result from 280E just make it very difficult to run a business, particularly, which is the second point, if the state essentially allows the illicit market to operate freely, because the illicit cannabis can be a substitute good for state regulated cannabis. And if the substitute good is able to be sold at a significant discount to state legal cannabis, because again, they're not paying taxes, they're not complying with regulations, it allows the legal regulated market to be significantly undercut. So again, that's another big sort of California issue. You're basically getting hit on both sides, right? Competition that can undercut you, and then these very high state taxes. Another thing that's really hurting the industry is intoxicating hemp. So, this is your Delta 8s of the world. Again, in some places it is allowed to be sold freely with limited enforcement. And that provides another sort of alternative substitute good. Inflation. The big one, obviously, from my perspective as an attorney, is access to capital. The sort of early investors have come in. They've obviously, they've either been tapped out or maybe they've been burned in a few cases, and they've been reticent to put in additional capital. And at the same time, the institutional capital is still on the sidelines because it's federally illegal. So, the pool of potential investors is a little bit tapped out at this point. High number of licenses. This is really varies between states, but in some states like in Oklahoma, where they've issued, thousands of licenses, the competition, it's just, supply and demand. And then, price compression, market saturation. So in a few different states, you've seen wholesale prices, it's effectively collapse, like a Massachusetts or a Colorado. I'd say Massachusetts more recently. And as a result, if a lot of your business was built on wholesaling and that price collapses, it's going to put you in a difficult situation. So, all right, that's how we got here. Well, what's what's the situation today? You've got, again, so Cannabis 101, right? Each state is sort of its own universe, right? Despite what's going on the illicit side where stuff is being shipped nationally, on the state regulated side, it's its own universe, its own supply demand dynamics, et cetera, et cetera. So you see a wide range of maturity between these different markets. So you've got a Colorado, which is about as mature a cannabis market as you've got in the US. And then you've got New York, right, where you've only got a handful of stores open on the adult use side right now. It's very new. Wholesale prices are declining significantly. Again, that varies state by state. The wholesale in New York is going to be pretty high right now. Last time I was told, I think it's still pretty high. But that probably won't be the case in 3 years. So you want to look forward 3 years in New York, look at Massachusetts, and look at the wholesale prices. Customers remain very price sensitive. The heavy cannabis user is very price sensitive. So that's econ 101. The price is very, it's elastic. People will respond to prices. California is leading the way. And then, big ones like MSOs dropping out of certain markets, Curaleaf in Colorado, California, and Oregon. This is sort of a reversal from previous trends where you saw MSOs trying to expand nationally, be in the most states. Now it looks like the trend is, people want to be narrowly focused, right?
Yeah, I think it's a refocus of a lot of bigger companies, and then some changes that were expected for medium and smaller companies.
I think what's happening, people are battening down the hatches, right? If you're in an environment where you can't raise capital easily, you've either got to become profitable or really slow down your burn, right?
Yes.
So the easiest way to do that is just withdraw out of certain operations and refocus in other states.
Yes.
So
when you see a state like Massachusetts, where the price of wholesales has been divided by at least 4 in the past 12 or 15 months, and California has been the same, Michigan has been the same, Oklahoma has been the same, Arizona had the same similar impact. Of course, as a company, you want to readjust your forecast and your strategy.
Yeah, and the other thing you're seeing, even within states where people aren't necessarily withdrawing from states, they're shuttering certain facilities. So people are trying to get tight. And then, you see capital raises are down, both the size of the number of raises and the size of the raises. Viridian, I think, puts out a very good report that I like to read. Tends to be focused on the public side just because that's easily available. On the private side, people tend to really only announce things when they want to brag about it. Yeah, and then obviously M&A is down as well. I don't think we're going to see your mega M&A deals this year, but I mean, focused M&A remains active. FL.
All right. Well, with that news, this program obviously is on receiverships. And why are receiverships so important in the cannabis industry? Because for the most part, bankruptcy is not an option for operators. And bankruptcy, one of the nice items for bankruptcy, if you have a very difficult lender or you have some difficult contracts, you have the automatic stay provision of bankruptcy. In some cases, you can reject leases that are too expensive. You can reject some contracts. And there's an orderly system set up to, give you a little time to reorganize your debts. And for the most part, bankruptcy has not been available in the cannabis industry. And what you see is 2 main arguments why or policy platforms why you shouldn't be able to file for bankruptcy. One, if you're going to have any sort of reorganization plan, whether it's in a Chapter 11 or a Chapter 13, the concept is you shouldn't be able to use proceeds from an illegal activity to fund your plan. And then the other big policy argument that is introduced is bankruptcy trustees should not be required to administer assets that would cause them to violate federal criminal law. And in bankruptcy cases, you have the debtor, you have the creditor, you have the judges, but you have the U.S. Trustee's Office, which oversees, the bankruptcy cases really on behalf of the government. And in the notes here, there's a big white paper they put out in 2017, why basically marijuana assets, cannot be administered in bankruptcy, whether you're a grower or a cultivator, or you're some sort of downstream operator. And primarily because, again, it's federally illegal. And, what this next slide is, it talks about the sections of the Controlled Substances Act, which make cannabis illegal, whether it's renting, managing, or using property for the purpose of manufacturing, distributing controlled substances. It's a crime to sell or offer for sale any drug paraphernalia, which would include equipment to be produced or used in connection with a controlled substance, or it's a crime, if you're going to derive any profit from the controlled substance, which in this case, obviously, is the cannabis. And then, starting really, like in 2010, when it first became legal in Colorado, there's been a body of case law that's developed where certainly some clear instances where the cases were basically thrown out of bankruptcy. A medical marijuana dispensary dismissed because the only way they could fund their reorganization plan was by selling cannabis. Seems pretty clear. And in 2015, a Colorado grower was found not to be eligible for Chapter 7 because it would require the trustee to deal with cannabis. There's a case here, Burton versus Maney, where a Chapter 13 case was dismissed because the recovery, the plan was to be funded by the recovery of lawsuit proceeds resulting from breach of contracts for cultivation and sale of marijuana. So that was a little further removed. And then there's one here, In Ray Way to Grow, where it was a hydroponic supply company that was selling to cannabis growers, and the court ruled that no, that company was not eligible for bankruptcy.
Yeah, FL, that's an interesting case for people that think about listing issues, because it goes into what they consider aiding and abetting. And they didn't kick them out for aiding and abetting violations of the CSA. They kicked him out because they violated a specific prong of the CSA, equipment used to manufacture. So it's interesting. I mean, it's interesting for people like me because there's not a ton of case law where they discuss what aiding and abetting means in the context of cannabis, because, the modern era of cannabis changed the game on aiding and abetting. Like none of these, there's no like tech companies aiding and abetting the sale of other Schedule I drugs like crack, right? So there's very limited case law on these kind of things.
And yet, just a couple of weeks ago, there seemed to be a little chink in the armor as far as kicking the cannabis companies out of bankruptcy. In this, the Hacienda Company, it's a California case. They manufactured and packaged cannabis, and they ended up selling their operations, their IP, to a Canadian company, Lowell Farms. And in exchange, they got equity shares in Lowell Farms. The United States Trustee's Office moved to dismiss the case because the case essentially would be funded from the sale of those equity shares in the Canadian cannabis company, Lowell Farms. But the court denied the U.S. trustees motion. It really is like it's going to be a watershed case. You're going to be hearing a lot more about it. But the certain quotes in the case are: the mere presence of marijuana near a bankruptcy case doesn't automatically prohibit a debtor from filing, and to the extent that it's passive stock ownership, in the Canadian cannabis company with the intent to sell that to pay creditors, apparently that didn't bother the court. And then the Congress didn't adopt a zero tolerance party. And no, there's no per se rule requiring dismissal of a case where marijuana is present. And the case also talks about other situations like Bernie Madoff, Enron, some of the stuff that's going on with the the Roman Catholic Diocese. There's other situations where there's illegal activity, and yet the Chapter 11 case has been they've allowed that to continue. And then also in my notes, I talk about a case out of the state of Washington where there was a reorganization plan. The debtor owned, had several leases for commercial property. One of the lease was a lease to a cannabis farmer, and because the revenue from the lease to the cannabis farmer was not going to be used to fund the reorganization plan, the bankruptcy appellate court out of the Ninth Circuit said that was all right. You can still confirm the plan. So as you're seeing some movement, some opening in certain situations to allow a bankruptcy filing and a cannabis operation. And I just wonder, especially with that Hacienda company, to the extent that the SAFE Act didn't pass at the end of the year, there is such a dearth of capital in the industry, and there's a lot of distress right now. Maybe courts are going to think, well, it might be better to let somebody in a bankruptcy case so there can be an orderly liquidation of the assets. And then the next slide, bankruptcy and cannabis in Canada, as you know, in Canada, cannabis is federally legal, so you can make use of the Companies Creditors Arrangement Act in Canada, which is very similar to a Chapter 11. You have to either be incorporated in Canada or a foreign incorporated company with assets in Canada, and you have to have at least $5 million in debts. It's similar to a Chapter 11 case. You do get an automatic stay, but it's interesting. In the U.S., when you file your automatic stay, there's really no end period unless somebody moves to dismiss the case. In Canada, you get a stay for 10 days, and then you have to make a motion to extend it. And then the other thing they have in Canada, which I find is very interesting, and if you want to go to the next slide, it's called a reverse vesting order. So in Canada, like many states in the U.S., the Canada Revenue Agency can suspend or cancel a cannabis license if the operator becomes bankrupt or subject of a receivership proceeding. In the Cannabis Act in Canada, you can't transfer a cannabis license. So what we have seen with some of the bankruptcy cases, the reorganization cases in Canada, is they do this reverse vesting order. So they basically take all the unwanted assets out of the company that filed and they put it into another company, the residual company. And so the company that's filed basically has cleaned their assets. And then that company actually emerges from bankruptcy. And because the license hasn't been transferred, they can continue to operate. And several cannabis companies in Canada have used this reverse vesting order to, so to speak, stay alive. Then another issue that I anticipate workout people, turnaround management consultants may start thinking more about is a Chapter 15 bankruptcy, where if you had a bankruptcy in Canada, you could file a Chapter 15 proceeding in the US to try and make use of the automatic stay provision in the US. And one of the things about the Chapter 15 under the US bankruptcy code is there is not an estate created of the debtor's assets. And, one of the reasons why the US trustee, is trying to move to dismiss bankruptcy cases is because they don't want the trustee to have to administer assets, and that wouldn't happen in a Chapter 15. So what I'm looking for now is bankruptcy cases maybe that end up getting filed in Canada and they move for some sort of protective stay under Chapter 15 in the US. And I anticipate the US Trustee's Office is going to say that foreign proceeding shouldn't be recognized because it's manifestly contrary to the public policy of the US. But I think the Hacienda case out of California is going to give debtors counsel some grounds to argue that, in fact, filing, making use of the Chapter 15 is not, in fact, going to be manifestly contrary to the public policy of the U.S. But in any event, using all the bells and whistles of the bankruptcy court in the U.S. right now is generally not available to cannabis companies, and that's why we need the receiverships. And I'll turn it over to my colleagues at this point.
All right. Well, so at this point, it's pretty clear that we got to find another option if there's some financial trouble in the company. And we talked about where it's coming from. And here in the screen, you'll see a few options: out of court restructuring, state receivership, and all the others, and including winding down the company if the state statute allow it. But in the next slide, we're going to talk about the receivership and how it's an alternative to bankruptcy or any business conflict resolution. We saw earlier, some of the potential issues that are now in the industry. We are forecasting that outside of the new states coming online that will get probably mature very soon, there's a lot of uncertainty for a lot of companies on many markets. We are been involved in recent receivership for Airmont Inc. in Massachusetts, and most of those here apply for that case. That's the first receivership in Massachusetts. Massachusetts has became pretty mature, too many licenses, a lot of producer. Then most companies have been missing some operational skills, lack of forecasting, expectation that were not realistic, and of course, financing structure that were sometimes too much of a burden on the company. So all these reasons here are why receivership could happen to companies around us in the cannabis industry. In the next slide, we're looking at which perspective, why receivership, from which angle. So we talked about the fact that the traditional financing is not really available. It's becoming more and more available. There's a lot of new options, but the fact that some states for a long time were requiring non-profit structure versus the traditional for-profit has led to some financing that were a little bit, actually very creative, and private loans, real estate-based loans, and that now a few years later creates some issues at the operational level. Then for the borrower, sometimes they have not realized all the reps and warranties and covenants that they were supposed to follow. They didn't really realize the rates that they were paying, compounding interest and pledge of licenses, and they're getting to a point that the operation is suffering. And then from the lender perspective, some lenders also did not realize that they had limitation on their rights, and they couldn't access the collateral, they couldn't access the assets, they couldn't access the financials. So they are living in the dark with not seeing any of their return, the return they were expecting. So so in that case, receivership in the next slide is the option. So what does that mean, right? When bankruptcy is not an option, what does that mean? Well, in this case, it's a flexible way to resolve the business and financial conflicts for the best outcome to all the parties while the operation is continuing. To me, that's a good definition, because the goal is really to maximize the value and keep the company going. And while the operation is ongoing, the license is active and compliant, the staff is still on site, the customers or the patients can find their products. The professionals around the company are looking at finding a solution. Like Charlie was saying earlier, the receivership is a teamwork. We've been working with bankruptcy attorney, receivership attorney, and other consultants like us, to make those restructuring happen. So who's going to use the receivership? It can come from different angles. Here, we couldn't really list all the participants or the source. Obviously, the lender is probably number one. I got a loan out there. I haven't seen a payment in a while. What are my options? Hopefully it can be done out of court and find a solution. But most of the time, when in that situation, receivership can be a good option. The operators finding that they are a little bit too much under pressure. We talked about landlord. I think it's UFL wanted to mention maybe that landlords could see that as an option, right, when they own the building, and find a way to get their return.
Yeah, I think be helpful for a landlord, because they could get some clarity as to, the rent payment while, there's inventory in the building, and I think, a court that's not used to dealing with, say, an eviction, of a cannabis company, I think the receivership could even out the process and require at least ongoing payments to the landlord during the receivership.
So what are the advantages of the receivership, and why would you consider it? So it does offer some advantage to the company and to the creditors. Probably not as much, and we're going to talk about the difference between bankruptcy and receivership, but not as much as the bankruptcy, but still does. One of the advantage is that there's a potential prepackaging of the outcome and the goals of the receivership, right? You can put a pool of cash for the unsecured. You can talk about the secured collateral. So it allows, for negotiation. There's some safeguards too, again, fell on certain leases and contracts, right, that you can put aside. And then to me, one of the biggest ones, so I'm not an attorney, I'm not a lawyer. I'm a pragmatic business person, and access to information is, I think, a way to resolve the situation. I've seen cannabis or non-cannabis, a lot of conflicts happen because there's a lack of communication. And I think receivership gives access to information, financial reporting, cash flow forecasting, 13-week cash flow, where's the company going? And then at that point, all the parties can start talking about the reality of what's going on, where sometimes one of the parties is in the dark. There is flexibility also compared to other options on the cost, right? There's probably it's much cheaper than bankruptcy for sure, and there's a better understanding of the fees. Timing is also a consideration. Although the cannabis compliance schemes are most of the time very complex and can slow down the process. We've seen it in a few cases in the past year. You need to stay compliant. You need to have authorization from the Cannabis Commission, whatever the state is calling it. So it can slow down, but it can be efficient on the time side. And also,
Just to
go ahead.
jump in and not to, because I'm gonna speed through my slides, but the big
Yes,
take
I'm trying.
cannabis, the cannabis compliance side is that you need, depending on the state and like the states you're talking about, like California, Massachusetts, you need both state and local approval 9 times out of 10 to do these deals. So that can really mess up your timing, right? Because now you need not just 1 but 2 regulatory bodies. And the locals, as we'll talk about later, there are rules at the state level, but these towns don't update their ordinances when the state laws change. I mean, you don't have the ability as a town to keep your ordinances up to date like that.
And then, Jacques,
go ahead.
You mentioned something about eliminating certain leases. I know they had another recent receivership filing in Massachusetts, and the receivership order gave the receiver authority to basically terminate leases, expensive leases. So I thought that was pretty good.
Yes, and that's an advantage. A lot of leases in the cannabis industry are way over market, and that probably is a big relief for those companies. Yeah, and I'm trying to speed up on the slides because I see the clock going. But the other advantage are access to experts and find solution. Here we try to compare bankruptcy versus receivership. Maybe FL, you want to mention a few items here.
Well, I mean, the automatic stay is important, but I know, it's in some courts. I mean, the judge can decide to put in a limited stay, just like in bankruptcy. I mean, you're not guaranteed that, but if you know you're getting that coming in, so that's pretty good. We just talked about the order where you can reject leases and you reject certain contracts. That's certainly one of the big benefits. And then I guess, in bankruptcy, there's also the reality of, what are you going to get paid at the end of the day? And my sense is in receiverships, people can have a good dose of realism as to what the value of the company is and what money is going to be left over.
Yes.
Yeah, and I would just add to this. I mean, from what I've seen, one thing is to understand is that the receivership laws differ from state to state. So it's not like federal bankruptcy where, there's only one system you need to know and you can pretty much count on it working that way, no matter where the business is. You do see variety in different state receivership laws. And the other big sort of difference in my view is the receivership, really does seem to provide a lot more leeway to the judge to make a decision one way or the other. So, you don't have sort of, if you've been through 20 federal bankruptcies, and you got a new one coming up, you can pretty much know what's going to happen, what order is going to happen. In receivership, it's a lot more open.
Agreed.
So what to consider when you think that the receivership process is an option? We talked about the process and that consensus around the process. I think that gives access to that gives access to the knowledge of experts. And so if you decide to go the receivership direction, making sure that the team has the turnarounds or bankruptcy credentials, going back to our comments earlier about having the right legal team, and also knowledge of the industry. Of course, having knowledge about business and understanding cash flow, I think that's very, very important. What we found out too is knowing the ins and outs of the operation is pretty important. Cannabis, but in general about restructuring practices and or how those cannabis operations are working, and understanding who is who in the industry, having the network to be able to connect the dots and make sure that the company continue to operate with some kind of a profit. I think time is passing by, my friends, so we got to speed up a little bit here. Otherwise, we're not going to have a chance to answer some questions. But I think the other considerations here for are again making sure that you have the right team, and also that it's a transparent, proactive, and practical process. There's a lot of things to resolve, and taxes, cash flow reporting. So those things are to be completed. I want to go to, yeah, go ahead.
Yeah, Jack. So you're a receiver in a case in Massachusetts.
Yes.
And what sort of reporting is the court requiring of you? Is it monthly cash flow statements?
Yeah.
Do you have a regular meeting, every 4 to 6 weeks? How's that working?
So in this case, we had a monthly reporting to the court and to all the stakeholders. So weekly cash flow filed monthly. So to give an idea to all the stakeholders in the court, how much cash is available and how it's going to be used, comparing to forecasts and actuals, as well as a report monthly about the activity of the company and where we stand, what we've done, what's happening. So all the parties are aware of the progress of the receivership.
And what sort of interaction did you have with the Massachusetts Cannabis Control Board?
So we had to be approved initially by the commission to be able to access the facility and take over the management of the company. And then on an ongoing basis, we kept them appraised of the major progress. They were part of all the filings, so they received the filings. But we also make sure that we're having an ongoing open communication with them, particularly around the renewal of the license that happened, in 2022, and making sure that the company could stay compliant with all the rules and regulations, and also with the end of the receivership, which we are working on right now. The court approved our transition plan, and so making sure that the change of control is approved and all the paperwork is filed appropriately. And that is a good segue for this part of the presentation about what does success look like. It's a little bit of like a triple bottom line approach, where we want to make sure that the company stays open and does not shut down. Make sure that every creditors gets something back, right? It's got to be realistic, but hoping that everybody gets something back. On the social part, making sure that jobs are still there. People can still get their jobs, but also their products. And there's a limited impact on the community. I think to me too, in the case of the receivership that we are working on, want to make sure too that it has a positive impact on the industry. It's very difficult to continue to have an industry growing if we start having a negative impact from receivership, companies getting into receivership. So we didn't want to see that case as an industry failure. And I think those are the major point to me on what does success look like for receivership.
So in your case, the receivership, it was sort of like a sale plan. You stabilized the company.
Yes.
And you found a buyer, and ideally the buyer's gonna retain some of the employees.
Yeah, the company was still, sales were pretty good. It's medical cannabis, one of the first license in Massachusetts, good sales. So we worked on different strategies. The court approved the strategy of selling the assets of the company and transfer the license. So we worked on finding a buyer. The buyer has been approved, and now we're in that transition mode where as soon as the Cannabis Control Commission approves the change of control, then the assets will be transferred to the new buyer, and the company will continue to progress. The employees will keep their job, and there will be a new future for the company.
And I don't know if you can discuss this, but did you run like a formal auction process? Were bankers involved at all in that?
No bankers were involved. So I thought about having a formal process, but come to find out that the industry is still small, and the number of potential buyers could be counted on one hand of maybe a couple of two hands. So we obviously talked to as many people as we could, but we did not hire a formal banker. We used our network and reached out to a lot of people and ended up having a few options and picked, I think, a really good option.
Yeah, I was going to say my experience with people selling assets in cannabis is if you know something's for sale and you mention someone else like, hey, are you interested in
Yes.
buying a dispensary in Maryland, such and such, they'll say, oh, is it X? People
Yes.
know about these deals.
Yes.
As you're telling them. Yeah, I think that's super interesting. And I would say that my understanding of the CCAA processes is that there haven't really been many bidders. I think in a lot of cases, there was only been one bidder. So the same concerns you have in a typical bankruptcy where people don't want to act as a stalking horse and sort of set a bench line for other people don't really apply because if there's only one bidder, the stalking horse concept isn't really relevant.
Yeah. And there was also a little bit of a publicity part of this, right? Want to make sure that one case being too public have an impact on other companies and valuation of other companies and the value of an entire state, an entire market. So, I think the process we run was efficient, and within 3-4 months we had a letter of intent in place, and we could get back to the court and continue to resolve the situation.
Excellent.
And how about payouts to unsecured creditors? I mean, how did that work, or will it work?
Yeah. So the creditors prior to the receivership, outside of the secured creditor, right, were so all the unsecured creditors had to wait for the receivership options, right, to be approved, and we were able to negotiate, a certain amount of proceeds going to the unsecured. So that was part of all the negotiation that happened with the court and all the parties.
Was there any sort of equivalent of like a debtor in possession or like an ongoing loan to the company during the receivership process?
If you don't mind, I probably would skip that question, but that was an option. It should be an option.
Yeah, of course. Sorry. Okay, so I'm just gonna kind of sprint through the state by state stuff. So we're going to talk about Massachusetts, California, and New York here. I'll give you the real simple answer here so we can turn to questions. Massachusetts and California both have systems to transfer license at the state level. The Massachusetts rules are a lot more in depth than the California rules. What I view as sort of the X factor in both these states is neither address the local licenses, and local licenses are very important in both California and in Massachusetts. So if you got everything lined up in Massachusetts and the town says, hey, you can't transfer your host community agreement to this new buyer, then the deal's dead. So it's something you got to think about ahead of time. Again, with these towns, it can really run the gamut. If the license is issued pursuant to a specific town ordinance, these ordinances are not revisited like state laws, with adjustments every year because the towns have a lot to do. And there are not that many people working at the town office. That's pretty much it. And then New York currently does not address receiverships. You're going to have to rely on a traditional change of control in New York, which is basically a no-go because it's going to take so long to get approval. The company will have gone under by then, which is why people have these receivership statutes. But it does seem like people are open to amending the law to create a receivership statute. Now, if you look at these receivership statutes, like if you look at Massachusetts, it's not just receivership. So you could have essentially use the same process for a court appointee. Let's say that the business was owned by one individual and that individual passed away, right? Some sort of transfer upon death or, eventually federal bankruptcy. If you've got licenses in multiple states, you're going to have to deal with multiple regulatory agencies. They're not going to necessarily recognize the receiverships in other states. So be prepared for that. And with that said, and with 10 minutes left, let's turn to questions here. Okay. I'm going to find some good questions for the group here, right? So if a client has subsidiaries in different states, do you need separate receivership proceedings, one in each state? The answer is going to have to be yes. And that shows you why this receivership stuff is not traditionally used in traditional transactions, because it becomes very unwieldy if you're dealing with a multi-state operator.
Yeah, but the receivership, the receiver could be part of the same company.
Yeah, but they would have to be appointed by multiple states.
Absolutely, yes.
Yeah, that's a great point. Thank you. So it's not so question, what's an assignment for the benefit for creditors? I mean, that's a wind down of the company. You know, essentially someone steps in and sells off all the assets and distributes the capital to the creditors.
Yeah, so you'd have a buyer that was interested in acquiring the company. There's a certain amount that they're going to be paid, and then the proceeds are going to the creditors.
Yeah, so one of the challenges, you know, with receivership versus bankruptcy is, you know, bankruptcy contains within itself, you know, a restructuring Chapter 11 and also kind of a wind down. You know, ABCs are traditionally seen as just a wind down. And not necessarily a way to keep the business open, because I don't think an ABC really contemplates staying open for long enough to, you know, to find a new buyer. So if there was an ABC for cannabis business, I would envision it probably, you know, they might sell the lights and you sell the flower, but then you shut down the business.
Yeah, because you got to keep in mind that usually the cannabis product cannot be, you know, passed to somebody who does not have a license. And so you know, if you're winding down, you have to either sell it to other operators or get rid of it and destroy it.
Okay, what about Colorado? So just real quick, yeah, there's a receivership. The regulations in Colorado contemplate receiverships and other types of court appointees. So you can do it in Colorado. The key thing here is with receivership is it has these state statutes and the accompanying regs allow you to move quickly to put someone in place. Because in Colorado, for example, a traditional change of control could take you, you know, 1 to 4 months. So if a business is running into cash flow issues and the creditors are circling and potentially bringing judgments against it, if you have to wait 4 months for an approval for a new party to come in and control the business, it's just not tenable. That's why you need a receiver to come in quickly, and you also need at least the potential of a limited stay to protect the business, so you can maximize the value of the assets. Yeah, so I guess to answer Renee's question, you know, like the COO process is a little bit different for receivership in Colorado. You know, they will still want to look at the receiver. And, you know, in Massachusetts, the regulations are very clear that the receiver, so Jacques, for example, he couldn't be the receiver for 7 different companies in Massachusetts at any given time. He's still subject to the license cap, which is, you know, one of the big limiting factors in Massachusetts.
I saw a question about what if the company needs a cash infusion while going under the receivership process? And that is a good question because usually there's a cash flow issue when you start the receivership, right? And we actually had, and I would suggest that this is part of the receivership order, that entertain the option of having a cash infusion, most likely from the secured lender. So then they are secured, and part of the receivership is for them to get their money back.
Great. So sorry. So yeah, question here from Allison. Is there data on how many US cannabis companies are under receivership? That's a very interesting question. I haven't seen a report on it. I mean, I can tell you there are 2 in Massachusetts right now, at least that I'm aware of. California, there have been a bunch. There have been a handful in Colorado. Not every state has a receivership provision, like we were saying, with respect to cannabis companies. FL, Jacques, are you aware of any databases on this?
No. I know there's been a few in Nevada. There's a few in California, but you know, I don't know of any database that actually lists them all.
The challenge, I mean, while these are public filings, You have to know the name of the company to find the public filing. And most of these companies, at least to date, are private. So it's tough to generate good data sets with private companies. Ianthus, which owns a number of licenses in the US, including in Massachusetts, went through a CCAA restructuring. So I think, if and when we see a public company try and do this, it's going to be, you'll get a little bit more data, but for now it's tough to do analysis on private companies.
I agree. And then in some situations, just like maybe you want to do a receivership instead of bankruptcy because, it might be a way to do it, save some money, make it a little faster. You may also be in a workout situation where if you have a limited number of players, maybe you can, do the restructuring without doing the receivership. Because I think like what Jacques was alluding to, I mean, many of these cases, the secure creditors probably, sort of controlling the game and, and what's the way for them to, as quickly and efficiently, recover their investment.
Yeah, that's a great point, FL, and that's where a lot of the stuff we're working on right now comes into play, where you don't necessarily have to go into receivership for receivership to impact the transaction, because just like with the bankruptcy, everyone knows what the alternative is to a negotiated agreement. If everyone knows that receivership is the alternative, they're going to use that to calculate what they can realistically expect to get in a workout. Okay, so I'm going to combine two questions. What controlling power does the owner have under receivership? Are they able to sell, transfer the license while under receivership? And what is the process for approval of receiver en masse, as they will have influence and control? How long a process, and will it require vote at a public meeting? So the example, under the regs in Massachusetts, it is delegated to the executive director. So you can put a receiver in without having a public meeting, which is critical, right? Because the public meeting is going to slow down the process. So you can get that receiver in Massachusetts very quickly. It's the sale of the license from the receiver to a third party that is going to take longer. So yes, you can sell your license under receivership, but it's subject to a separate regulatory approval process. And, when it's under receivership, the owner no longer has controlling power. It's the receiver that's the captain, and is going to be making the decisions.
In Massachusetts, you follow the same rules, or the same process, I should say, than any other chain of control, right? The CCC in Massachusetts has a process, and you have to provide all the same documents. There's no shortcuts. Somehow, a little bit unfortunately, because there's obviously a pressing issue, right, that you want to resolve right away. There's a cash issue, but the process is the same than any other change of control that somebody's selling the company.
Yeah, so think of it as bifurcated, right? Putting the receiver in, that's that special expedited process that can happen very quickly. That you can also apply to be sort of added to a list of approved receivers in advance in Massachusetts. And then the second half of it, the sale to the third party, that's going to be like any other sale in Massachusetts. So it's not the full process of applying for an original license, but it is it's a time intensive process at the state and local level. So that's going to take a lot longer, that second half.
Yeah, outside of the legal benefits and that we mentioned in some of the financial benefits, really the receivership helps with the negotiation of a difficult financial situation, and allows for people to communicate and all work together to try to find through the court something that's going to work out for everybody. To me, that's what we have to keep in mind, but it still have to follow the same process than any other companies.
So Jacques, who initiated the receivership where you're the receiver? Was that the operator, or was that the secured lender?
Secured lender.
Okay.
Secured lender. Those information is public. The company had a loan, and the note was sold, and the note holder was looking for reimbursement of his loan. And after a month of trying, pushed or asked for the company to go in receivership so they could have access to financials and finding a solution to the problem.
Because there wouldn't be anything that would prevent the operator from filing if the lender's, not willing to bend at all.
So that may depend on state law, but in Massachusetts, the company can petition for a receiver to be appointed, or a creditor could be petitioned for a receiver to be appointed. So, they could get appointed a couple different ways. So everyone, that brings us to time here. So slides will be sent out to everyone. We're going to put this up on YouTube, so you can watch it and rewatch it to your heart's content.
Yes.
And obviously, reach out if you want to chat about anything. These are all interesting things. And if you're a receivership attorney, please reach out too. I'd love to talk about this stuff. As you can tell, the nitty gritties of the receivership law is something that requires a very specialized type of lawyer. But it impacts these workouts that we're going to see and be working a lot in 2023. So thanks everyone for joining, and keep your eye on your email for the slides.
Thank you. Thank you very much.